The Fifth Circuit Court of Appeals has ruled again earlier this month that the Horseracing Integrity and Safety Act and its resultant Horseracing Integrity and Safety Authority are unconstitutional. But the Sixth Circuit has ruled again that they are constitutional. What happens next? Well, we think eventually going to be a Supreme Court case. And what happens if the Supreme Court rules against HISA? Well, that's an interesting question. Here to help us figure out what exactly is going on with HISA and what could happen next if HISA were to be found unconstitutional, Eric Hamelback. He's the CEO of the National Horsemen's Benevolent Protective Association, the HBPA. HBPA has been spearheading the legal efforts to get HISA overturned, and he's going to explain to us why, what they think, what they see coming down the pike, and what might be after that if there is an after that. So Eric Hamelback about to join me here. My name is Frank Vespi. You are listening to Midlantic Racing Today, powered by The Racing Biz, theracingbiz.com. Please do like and subscribe for content just like this. We appreciate that very much. Here's Eric Hamelback. Eric, thanks for joining me. Appreciate you taking a few minutes to join us here on Midlantic Racing Today. Let's start with this. The big news earlier this month, the Fifth Circuit, a panel of the Fifth Circuit Court of Appeals struck down the Horseracing Integrity and Safety Act / authority for the second time. Tell us about this ruling and kind of what it means going forward.
Well, I'm glad to be here, Frank. Thanks again for inviting me on. Let me first say, though, it is the third time that the Fifth Circuit Court of Appeals has actually all three times given a unanimous decision from a three-judge panel that it is unconstitutional. So, what does it mean? You really have to put all the pieces together to really define and describe what it actually means. So everyone should remember that there is, I'll just say, two main cases, although there's three total cases on this plane of as applied challenges. Facial challenges. The converse is the as applied challenges. I'm sure your listeners have heard about the about the Serpy case and about the Jonathan Wong case. There's other cases that are classified as applied. So just take the three cases in the Fifth, Sixth, and Eighth. Those are the three cases that would be considered as facial challenges, just simply meaning on its face, we believe that the bill's unconstitutional and subsequently filed before HISA really took into implementation. So you've got the Sixth Circuit that did declare the bill once again unconstitutional. They've seen the bill twice, and you have to go back a couple of years now to really kind of get up to speed. The Fifth Circuit, they announced unconstitutional the first time way back in October of 2022. And then that's when Senator McConnell gave that little tweak and then gave the FTC a bit more power, as it were. But it didn't quite cover all of the issues that we had argued. But the Sixth Circuit found it unconstitutional. The Fifth Circuit then agreed to hear it again. So now we're into 2023.
I'm sorry, let me jump in. The Sixth Circuit found it constitutional, right?
Correct.
They said it was okay. Fifth Circuit said, no, it's not okay.
Well, the Fifth Circuit was the first one to rule.
Yeah.
Okay. The very first one to rule. So the original bill that was filed was found unconstitutional
in the Fifth Circuit.
In the Fifth Circuit. Senator McConnell and the bill sponsors, they did a one-sentence amendment, also put into a COVID relief package, and then that's when the Sixth Circuit heard it for the first time. Okay, so we're into 2023, March of 2023, and they pretty clearly said, in their opinion, if it hadn't been for the tweak, they would have also found it unconstitutional, but they found it constitutional. So the Fifth Circuit then agreed to hear it once again. They found it unconstitutional again, 2024. And then now, once we appealed and everybody was waiting at the Supreme Court, we waited until June or July of 2025. And we had been sitting on, and I described this somewhat layman-like, in that imagine the table that the Supreme Court justices sit around in the mornings, and they're picking up cases to look at, and what are we going to do today? They had every they had every chance to take our cases, if you will, and set them aside and say we're not going to listen to them. So essentially from November of 2024 all the way until June of 2025, we didn't hear anything until the first part of July in 2025. They what I learned now is GVR the case. So that means they granted cert, which is a positive, meaning they want to hear the case, but they vacated the opinions that were rendered by the lower courts. So pretend as if those opinions no longer exist. And then they remanded them. They sent them back down to the lower courts. And we said, or the Supreme Court said, look, I want you to hear these cases again. And I want you to keep in mind another case that the Supreme Court had heard earlier in the year. And I'm not going to get into all that, and nor do I claim to understand it, but there was a similar case that had to do with public non-delegation doctrine, whereas ours is based on private non-delegation doctrine, which again, layman's terms, which I am, just means the federal government cannot give government powers to a private entity. And everyone, including HISA, has continued to say that they are a private entity. So that's the basis of where we are. But all that said, the GVR hearings, so these new hearings had to take place. And ultimately, we found out the Fifth Circuit, in a more detailed opinion, but still upheld the unconstitutional opinion. The Sixth Circuit, actually pretty quickly after the GVR, said, no, it's constitutional. So all that being said, you can essentially say we wasted a year and a half, and we're right back where we were at the Supreme Court steps. Now, they're on recess. We didn't plan to hear anything before they went on recess for the summer. So best case scenario is that we'll find out in the fall that we'll have a hearing sometime after the first of the year, with the anticipation of having an opinion sometime around now of 2027. So that's an expedited track by means, by no means, I should say, are the justices on our timeline. We're on theirs. They most definitely could just sit on the case until they find some time again. But the one thing that you can say, no matter which side that you're on, there are justices that want to hear this case. And while I never took into account when we urged this position to move forward and do our due diligence to make sure this was correct, there are a lot of things tied to this non-delegation doctrine that have been percolating for quite some time. A lot of different political fronts that could change if we, quote unquote, win the case. There are a lot of different areas that could change. So that's why you've actually seen certainly non-horse racing entities send in amicus briefs or friends of the court to us, because they're arguing other cases that are similar, non-delegation doctrine in particular, that are not associated with horse racing. So we'll see. But all that to say, I'm firmly in belief that there are several Supreme Court justices that would like to hear this case, and then we'll see, what happens from there.
So, as I correct me if I'm wrong, as I understand it, the the first case that got fixed with the tweak, essentially the issue had to do with the process in the issuance of regulations, and that the FTC didn't have really sufficient oversight over the regulations that HISA promulgated. And so Congress fixed that, said, okay, FTC, you have additional authorities, and there you go. This case turns on, as I understand it, the enforcement of the rules.
Exactly.
So can you just talk a little bit about, I mean, how would it, I guess the question I'm moving in the direction of, is there a tweak that would fix this, or is there a way to remedy it, or is it impossible to, if one,
Is there a fix for that particular issue?
If Congress wanted to.
Yeah. In the second and the third opinion from the Fifth Circuit is when they really drew down on the enforcement of the law, of the bill itself, and how it was being enforced. That question, I believe, is answered in the opinion that's mainly found in the second opinion from the Fifth Circuit, because it actually says that the enforcement agency or the enforcement arm that's written into the bill is so intertwined into the rest of the bill that there isn't an obvious fix. That can certainly be argued one way or the other. And I had never seen or never been at least approached trying to write any red line that could possibly fix the enforcement arm. But what I will say, and I know we're going to talk about the RHSA, that had a lot of impetus in how we drafted and constructed the RHSA, because I think still to this day, and you go all the way now back to 2021, when USADA kind of came off the table, as it were, as being considered for the enforcement agency, and then we morphed into drug-free sports, and then the establishment of HIWU. I am still of the belief that there is an opportunity for the regulatory arm, if we just want to call it HISA, to ultimately do contracts with the state racing commissions. So again, to your point, to very clear, even the Fifth Circuit talked about the regulatory body and the lawmaking side of the act. They see no problem with it. They don't state that it's unconstitutional, but the enforcement of the rules and regulations are. Now they do say that because they're so intertwined, they didn't offer a solution. But I still feel as if there is a opportunity for there to be some sort of meshing and merging that could benefit the entire industry, for sure.
Because it seems like to me, it would be, and I hear what you're saying. You're saying essentially, if you move in a way where you're essentially enlisting the state commissions as the enforcement, that might take care of the issue. Because it does seem to me that if the Supreme Court buys the premise of the Fifth Circuit's ruling, it would be really hard to come up with a way that a private organization like HISA could enforce rules like this.
Absolutely. Absolutely. Yeah, I think that if the Supreme Court gives an affirmative opinion on, quote unquote, they can't do that, there's no way to fix that.
Yeah. Why is your membership, I assume this isn't Eric Hamelback and a couple lawyers out on a limb by themselves. Why is your membership so dead set on this issue?
So that's a great question, Frank, and one that we address on Capitol Hill a lot. And I typically start out by saying that, we as an organization did a lot of vetting on this bill. And again, going way back now, 11 years to 2015, when Andy Barr wrote his first new iteration. You know as well as I do, this bill's been around since 08, 09, I guess, but the newest version. And we actually ran it through a Congressional Research Service, the CRS, and they told us in 2015 that the bill as written is unlikely constitutional. Still carry around that PDF with me because that got the wheels turning. And I presented that to Congressman Barr. I mean, I consider Congressman Barr, I mean, he's my congressman, so we've gotten to know each other through the years. And you know, I let him know that this could be a problem. So that was at the time our number one opposition point. You know, hang on, guys. The way this is written, that this, you know, and I use the analogy: what if you got Trainer X on something real, that, you know, he really is performance enhancing his animals to win races, and then you take him to court and it gets thrown out because this is an unconstitutional bill. So that was really my premise, was trying to get folks to slow down, because it just didn't seem like the way the adjudication was set up that it was likely constitutional. You know, the second point that we really, you know, got, I guess, most upset about was the fact that the veterinary science was not written very well into the bill. You know, we've been used to the model rules, stakeholder input, and it was very clear from the minute the nominating committee was just picked out of nowhere, and then the authority members, no stakeholders had any input. That part didn't add up for us. And so the veterinary science aspect was very important to us. And I think we're seeing a lot of those problems now that, you know, we had thresholds and we had issues that we continued to work on in contamination. They just weren't set up. And then the third point of opposition at the time in the beginning was a little bit, you know, not as focused on, and that was the cost. And it was really because the cost wasn't addressed in the bill, other than to say the federal government's not going to give us any funding for this mandate. I asked Representative Barr, I sat down with Representative Barr and Representative Tonko and literally said, will you give us some sort of cost analysis of how this is going to be paid for, who's going to fund it, you know, and we never got an answer. And we didn't get an answer until right before the bill actually, or half of the bill, the safety and regulatory side, was implemented in July of 2022. And I think that first invoice was $66 million. So, you know, it's continued to go up. And so I say it in that way simply because now the finances have really become the number one demon of the act. And if it could get fixed, then there's something to talk about. But the industry cannot sustain itself. When you look at tracks like Emerald Downs, Finger Lakes, you know, tracks that are legitimately saying that they can't afford to race if they continue to pay this amount of money, or tracks in Nebraska and Colorado and Oregon, tracks that are just saying, we can't do it. We'll deal without the simulcasting. You know, Texas is a little bit different entity, and of course they're part of our lawsuit. But there are tracks that are just choosing what we would consider the football death penalty of not simulcasting their signal because they just flat out know they can't afford it. And now you have tracks saying either we're going to stop simulcasting or we're just going to shut down. That's become really the number one focus because, to your point, we have continued to push on various areas, and those areas have been rectified or paused. You know, I think that we've done a good job in trying to lighten or enlighten some of the problem areas. And now you're starting to see some changes that actually benefit horsemen. You know, I mean, obviously the Lasix issue, I mean, I'm not going to say anything other than I believe every horse should be allowed LASIX, but at least the authority members listened to us in a way that LASIX is, at least administered to certain conditions now. So, yeah, again, kind of a long-winded way to answer your question, but we were certainly dead set against it because of the obvious pursuit of prohibiting LASIX. We were very dead set against it by the way the bill was written, taking away the adjudication process and essentially putting it in the hands of a private adjudication panel. And then, for us, again, sidestepping some of the veterinary science and stakeholder input also had a big part of it.
You're listening to National HBPA CEO Eric Hamelback talk with Frank Vespi on Midlantic Racing Today.
Certainly.
How, I guess two questions. One, how relieved were you guys when they came back with the no change in LASIX decision? And two, does that blunt some of the passion that some of your membership has for fighting this fight, which has to be costing you guys a lot of money?
Let me answer that second part first. No, we, the National HBPA and our affiliates, haven't spent a dime. We were lucky enough in the very early stages through our connections in Washington, D.C. Our legal team has been pro bono since the very beginning. So I know I've said that before, but just to reiterate that point. But relief in the LASIX decision is a good word. But there was, and maybe I'll just say me, I don't want to say this about anybody else, that the nice way to say it is I told you so, right? We've been saying that, and I look, I grew up in Louisiana and I worked for a veterinary practice for years before I went to college, and then even after college. That was my first job out of college, was working for veterinarians. So, and growing up in Louisiana, you would see horses bleed with LASIX. But until you've, and I always use this scenario, I'm literally on the racetrack at Louisiana Downs, sitting on my butt with a filly that was trained by the Speck brothers, and she's bleeding out in my lap. So that gives you something to connect with. And while we don't see it that much anymore, I think it's because of LASIX. I think that there is that therapeutic side of, but it's almost like a vaccination. It isn't a vaccination. I don't want people to think that I believe that, but there's
we're against vaccinations now too, because everything
exactly.
old and stupid is new again. But that's a
exactly.
different
But just the prophylactic effect is positive from LASIK. So anyway, yes, there was relief, but there was also some condescending, going back to my other point, the sidestepping of veterinary science and research was very obvious to us in the way things were spelled out and the way folks, or who were selected to be a part of the initial grouping to quote unquote make the regulations. But I will give credit where credit is due. I spoke with Miss Lazarus, Lisa, on several occasions about LASIX. Actually, the second time we ever met, I spent the majority of my time trying to explain to her that furosemide was not the devil, and trying to explain to her what it was. And I didn't expect her to understand it. Coming from a different world, most people, especially coming from human sports, they do see LASIX as a performance enhancer. Because at the end of the day, they don't regulate when it could be given. But she, I believe, really came to understand that LASIX was not only from the veterinary aspect, but from the financial aspect. I said the one piece that folks don't talk about enough is the financial aspects of using furosemide. The example is you buy a $500,000 yearling, he gets to be a 2-year-old, and you're going to tell that owner that he can't, pay $25 for an insurance policy to help that horse not go through or suffer EIPH. That economic factor is a lot larger than I think most people realize. And when you don't have the opportunity to administer Lasix properly, horses don't come back as good. I think most people, they hear the word bleeding and they just assume they're going to physically see something. The reality is, if a horse bleeds out the nostrils, it's almost better than if they're just internally bleeding. Because I can remember as a kid at Louisiana Downs, you could go down the shed row and see 2 or 3 horses with thoracic tubes because they got lung infections because of the bleeding that went into their lungs. So the medical treatment, going back to the economics of bringing a horse out of an EIPH episode, is also a factor. So again, giving credit where credit is due, I do believe Miss Lazarus really came to understand that, respected that point, and she heard from a lot more people than me that it was beneficial, and that, quite frankly, with all the other changes that we had suffered in the industry, if the authority chose to just wipe it away and prohibit it, that was going to be pretty detrimental.
Why? I talked with Alan Foreman the other day, your colleague, former now retiring chairman of the Thoroughbred Horsemen's Associations, and you guys took basically the anti side. They ended up taking more or less the pro side. And Alan argued to me, and it's a fair question, I think, for you as well. His point is, this was going to come one way or another. We felt like we were better positioned to be on the inside, trying to help make it as
palatable,
make it work best for the industry. Why not do that?
I think that's a fair point. It's just a difference of philosophy. I certainly have spoken to a lot of folks in that Mid-Atlantic area. I get a lot of phone calls from, the reality is, and Alan knows this, and we both laugh about it sometimes. If you're a THA member, most likely you're an HBPA member as well, just depending on where you race. But there were a lot of folks that were, I'm just going to say, upset that the THA as a national group went the way it did, and it made a lot of horsemen, a lot of members upset. So to me, the choice was made, and I think Alan is certainly, obviously, as an attorney, very diplomatic. He's been around for decades and decades, and has the respect of folks at that level. I think that he believes he was right by being on the inside trying to fix it, instead of me being on the outside trying to bang on the door and say, no, this is wrong. I think at the end of the day, we both had the same sorts of opinions, and what needed to be changed is just a different way of getting it done. And so I think we've been effective. I think that certainly having Alan on the inside could have been effective, or was effective. So, it's just a difference of philosophy.
On the issue of funding, I mean, I've heard from tracks, same as you have, that the amount of money that's going to HISA really gets to be a problem for them. Now, HISA themselves have said, we're working to dramatically reduce what we have to take out of the industry. And in theory, they say within X number of years, they might get to, they might be somehow self-funding. Do you think that? Do you see that? Or are you not buying it?
in theory, Frank, I could make as much money as Lisa Lazarus in 5 years, and that ain't going to happen. So, um, no, I don't. I don't. I think if anything, there has to be a plateau to where at least it balances out. I mean, every startup company loses money. It's just the way it is, right? Because there are startup costs. So when is the industry going to get to that plateau where it levels out and it just becomes a sustainable operation? And what factors is it going to take to get it to there? But we've been on this trajectory of just going straight up now, essentially since 2022, July of 2022, with no real end in sight. There was a slight dip from last year to this year, but I mean, from 81 to 78 million, you know, that's still a lot of money. So I don't think that personally, and obviously I'm not on the inside. I don't think they have enough to market, to be able to sell, to be able to utilize, to pay for what they're doing now. I just don't see it. To me, there may be a cross at some point as they're going up on their economic funding, and the plateau comes, and maybe they can, sell something. Data is what continues to get thrown around. But I get nervous when they start talking about selling data. I mean, that's, at the end of the day,
What
I
is
don't.
that data?
Yeah, exactly.
Right.
Exactly. So, and I don't believe anybody on that side would sell individual data, but, and groups of data do make sense for some areas of research, but, I don't see that making money.
Yeah. Yeah. You and I talked about this a few months ago. There was a court case brought by Churchill and others saying that
Yeah.
their way of assessing the states was illegal, and
Mhm.
eventually they, I think, reached a settlement, right? Or was it a court ruling? I can't remember, but
Well, it was, I call it a pseudo settlement. That case is still active. I think some people, well, most people, maybe the way to say it, they heard that there was a settlement, and that settlement simply was a payment of some sort. They didn't completely pull everything back. So, I can't speak for Churchill, but having conversations with them, and having Churchill join us at a congressional briefing in D.C., learned a little bit myself. They still have major issues.
and they've been maintaining that the law only allows HISA to assess funds based on the number of racing days in a state per year. And the way HISA has been doing it combines racing days and purse levels.
Yeah.
And going to your earlier point, do we know? I mean, it seems like logically, if you move away from days plus purse levels to just days, that is going to hurt. You'd think a track like Charlestown, where their purses aren't going to be the highest, but if Charlestown ends up being under HISA, which it currently is not because West Virginia lawsuit, etc.
No, I understand your point.
But other smaller tracks where the purses aren't as high as the Churchills and Nairas of the world, but they race a lot of days.
Yeah.
Do we know?
No,
but do we have numbers on that?
It is a very much slippery slope, catch-22, whatever cliche you want to say, because you're right. I mean, the inverse causes problem with the other side. So whichever way you go, there are problems with the way it's calculated. And that's why, I guess, if I could wave a wand, we just need to figure out something needs to be done. It just can't cost this much money. It just can't. It just can't. So.
Because it doesn't seem. It seems like in general the commissions are still spending the money they were spending. It doesn't.
I mean, the reality is,
like it's additive, not replacement.
And part of the budget for the HISA HIWU group, they do issue credits now. Some of those credits, depending on how they're calculated, it may or may not add up to too much, but there is some thought to trying to push the money back to what the states may pay for. So it's as if that, that somebody's still paying that same amount of money. It's just coming out of a different wallet. But like you said, some commissions are paying more. And obviously the ones that the commissions, I mean, the ones that have multiple breed racing, they're still doing the same jobs. They're just, they're having to come and be there, but they're not necessarily going through the thoroughbred adjudications or investigations. They may not be doing that. Or, the HISA's kind of commandeered employees through some of their state contracts, and the state racing commission or the states have just agreed to continue to salary that individual.
You're listening to National HBPA CEO Eric Hamelback talk with Frank Vespi on Midlantic Racing Today.
An alternative called the Racehorse Health and Safety Act. Representative Clay Higgins and 4 co-sponsors, HR 3378, in the Senate, Senator Cotton from Arkansas. No co-sponsors, S 1770. Tell me about the legislation.
Sure, absolutely. And we did have with the House side 3378. It was introduced with a bipartisan fashion with Representative Don Davis from North Carolina, along with Representative Clay Higgins from Louisiana. So the bill, if you want to kind of classify it, was written in response to the second unconstitutional opinion. And it really is a basis around my belief that the state racing commissions need to stay involved in a major way. So the first thing, obviously, we looked at the state compacts that were tried years ago. Kentucky passed one, I think Maryland, Delaware. There were some state level compacts that were done to no avail. You really didn't get any buy-in, but they didn't have a stick either. Right. So what we did, putting our heads together with the United States Trotting Association, we got some input from the AQHA. We had input from the ARCI, taking a lot of stakeholder collaboration to try to put something together. And the first thing we tried to do, or make sure we did, was make it constitutional. So the way the bill was drafted, it was drafted as a compact, but a national compact. So national compacts, I've learned, are used in a multitude of industries. A compact is actually mentioned in the U.S. Constitution. So as an amendment, it was brought in as an understanding that states could work together under this compact from a federal nature. So it's different from what was tried before, where they just tried to get a state legislator to pass the compact that would be with other states. This compact is set up such that it then authorizes states to be in the compact. Why would you want to do that, right? First off, having a choice makes it constitutional. I've gotten some crossways conversations with folks about the choice. It's not going to be uniform if you give the states a choice. And I said, well, it's not going to be constitutional if a state doesn't get the choice. And that's where the Seventh Rights Amendment come in. And it is what it is. You can take it however you want. But what we've done is we have tied the interest of being in the compact to the simulcast signal. Okay, so we've breached it to the Interstate Horse Racing Act, just like the Horse Racing Integrity Act does now. The difference is, once you get into the details, we do it with the impetus of putting your state racing commission back in charge. So in other words, yes, you can join the compact, but you're not going to lose anything if you do that. If you join HISA now, you're going to lose a lot, including financial hardships that the industry is having. So once the compact is established, A state essentially has 2 years to join the compact, and then ultimately we set up, and I describe this more as a model rules committee, but it's described in the bill called the Racehorse Health and Safety Organization. And we have 9 members, just like the HISA authority does, but our 9 members are actually set up like the ARCI. So 5 of the 9 members would be seated automatically from the commissions based off of economic impact from the states. And that actually takes into account all 3 breeds. So quarter horse, standardbred, and thoroughbred. So your top 5, not really what you might think they would be, because a state like Pennsylvania comes into the top 3 because they have so much state standardbred racing, and Ohio, Louisiana, and West Virginia kind of teeter on number 5 because they have a lot of, or Louisiana in particular, a lot of quarter horse racing. But so the other 4 members would then be elected from the state racing commission. So a delegate from the other commissions, and that's the 9, what we call the Racehorse Health and Safety Organization, or the final stamp of anything that needs to be added, deleted, or modified. So what we've done is, and this is a conversation that goes all the way back to 2018 with Alan Foreman and Alex Waldrop and Ed Martin. Uniformity would have been a lot simpler for HISA if they just would have adopted the model rules from one state. Pick a state: California, Kentucky, Florida, Arkansas. If they would have just picked the model rules from one state and said, this is it, let's move forward, there would have been tremendous buy-in, because we've said it 100 times. Everybody bitched about not having uniformity, but nobody bitched about the rules themselves. And so HISA comes in and makes new rules. They do away with thresholds. They change contaminants. They change substances that have been therapeutic for years to banned substances. So nobody ever had a problem with the rules. So with the compact, with the RHSA, we are establishing the ARCI model rules as the set of rules. And so we move forward with the commissions in charge. So what ends up happening is the states then become, back in charge of their anti-doping laboratory. The commissions, the states, they return to the investigatory powers, the adjudication powers, and then ultimately the enforcement powers. But again, based all under the same model rules. And the reason that's beneficial is because, as well as I do, the rules of horse racing are actually state law. And a lot of people get lost in that feature, that it's actually a law. So in other words, I always use this comparison, right? I officiate high school football. If I throw a flag, that kid did not break a law. But if you get thrown a flag on horse racing, you've actually broken a law. And so what does that mean? Laws have to be changed in the General Assembly. So I always pick on Iowa when I do this. There was a time when they wanted to decrease the maximum amount of bute that could be given 48 hours out. And then Iowa, because their state legislature was churning about all this other stuff, they wouldn't get it passed. So at least their state commission did an in-house rule, and they lowered it down to 2 milligrams per mil. But my point is, if you're changing a law, it takes a while. But if you do it in a compact under the model rules, once one's changed, once this RHSO says we're changing this rule or we're adding this threshold, it goes for everybody that's in the compact. Now, could a state not join? Yes, they could not join.
Just like Texas has not joined.
Exactly, and they wouldn't have their simulcasting rights. So all of that to say, we're putting it back to the states.
Well, let's say I'm a skeptic. I'm also a little twisted this way. So I actually read the legislation, and yeah, I'm a little twisted this way. So I'm reading it, and let's say I'm a skeptic. I'm on the other side. I'm reading this. I'm saying, okay, so there's an organization, this RHSO. It's got a board of directors. It implements uniform national rules. Its board of directors sets its budget. It assesses the states for the budget. If a state doesn't participate, it loses its rights to simulcasting. Isn't this HISA by another name?
I mean, certainly a skeptic could see it that way. I mean, we think that the players, the individuals involved, returning to stakeholder collaboration and racing commissions is more beneficial than what we have now. We also feel like the budget, which is referenced, that goes back to the states as well. You know, several racing commissions that have just threw their hands up and said, look, we're not giving this federal entity any money. I mean, there are states that have it in their state constitution that say they can't give federal funding or can't give something for a federal mandate. So when you return that to the states, state appropriations are taking care of it. We're not collecting an additional $77 million to pay salaries and, you know, reduce the number of laboratories that we have and have this, you know, this team of investigators that go into a barn for somebody's regimate positive. So, you know, that ultimately is where the finances go back to the states. And we don't believe outside of a minimal administration sort of budget that there's going to be any costs associated with this outside the states. You know, I've thrown around,
right? I mean,
well, I've thrown around the number of 5%, you know, maybe 5% of what above what they pay now, because again, you know, there isn't an arm of employees that is going from state to state doing the same job. Your state's taking care of that job.
Now, you mentioned that the board members are going to be chosen in part by, or going to be chosen by the number of
racing days. Yeah.
But it's all breed racing days,
Yeah.
not.
Yeah.
And so this organization would regulate all breeds.
All breeds. Yeah.
But it would, as I understand the legislation, it would have breed specific regulations, though. You're not going to make the quarter horse guys live with the same things the thoroughbred guys do. And
that's correct. It's, yeah, you know, in the ARCI now, there's quarter horse standardbred regulations. There's even greyhound regulations, you know, within the ARCI model rules. So, you know, one of the things that I'm, I guess, most proud of is that within the RHSA, we actually set up 3 scientific advisory committees, one for each major racing breed. So quarter horses, standardbreds, and thoroughbreds would all have their own scientific advisory committee to make sure the anti-doping and medication control program is specific for their breed. Because while I always laugh and say a horse is a horse, yes, but an equine athlete, you know, there are breed specifics that do matter when you're talking about therapeutic medication.
Mm-hmm. Mm-hmm. So Higgins is from Louisiana. The co-sponsors are from Virginia, Delaware, Oklahoma, and North Carolina. I think 3 of the co-sponsors are Democrats. Higgins is a Republican. One of the co-sponsors is a Republican. What should we learn from that, if anything?
Everybody on the Hill is waiting for the Supreme Court to do or say something. You know, now my arguing point has been that, you know, we don't want to wait until there's another travesty like happened in Santa Anita for Congress to just pick up the first thing they see and ram it through. Matter of fact, we've actually been asked, what are you going to attach this to? And I said, well, to be quite honest, I want it to go through normal bill procedure. I want it to have a committee markup. I'm not saying that the group that put the bill together is the end all to be all. I want other eyes to give us input on the bill. But the fact that it doesn't have, you know, one, we're in energy and commerce on the House side, and we're in judiciary on the Senate side. And it's very different
committees. Yeah.
Yeah. Very, very difficult to get any sort of traction. and that's part of it. Is they know the Supreme Court's looking at this, and nobody wants to really make a choice or decide or be supportive of anything per se until the Supreme Court makes a decision. Unfortunately, they've been saying that for a while. And the reality is we've had 3 decisions made, or 5, if you want to say, include the 6. When are you going to move on that? So, but the other aspect too, Frank, and I'll just say it plainly, you know, I hear, feel, and even my wife sometimes feels all the negative that comes from, the labeled obstructionist. And I appreciate you saying earlier, it's not just Eric Hamelback doing this. But I heard that and I said, well, that was kind of the thought process of, well, if we're going to continue to push back, we need to have a solution. And so that's I guess the most major part of the RHSA is at least we've put forth a solution just to get a federal bill introduced. I had no idea. It is so freaking hard just to get something introduced, period. It is what it is, but I'm proud that we just pushed forward and at least we've got a solution. We're not saying it's the best solution or it's perfect as it is. We want other input, something that we did not get a chance to do in HISA. It was all theirs and they just moved it through. And that's part of the flag.
Who you said that you want a committee markup because you think that those of you who put this bill together are not necessarily the be all end all and font of all wisdom or whatever. Who else was involved in creating this other than the HBPA?
So we had many of an input from the USTA. They were probably between us and our lobbying group. We have the same lobbying group. And so they were very instrumental. NARV, the North American Association of Racetrack Veterinarians, particularly Dr. Andy Roberts, Dr. Clara Finger, Dr. Kim Brewer, a lot of their board members had input. Actually, it was their idea about having the breed specificity in the scientific advisory committees. Judge Walmsley from Arkansas, who was the Arkansas HBPA president, he was quite instrumental. Matter of fact, he's the reason we have that the RHSO can't do anything unless there's a super majority vote. So making sure that the 5 big members can't just run the whole thing. And then we also had input and asked questions from the AQHA, Janet Van Weber in particular, just making sure that they were, A, they knew they were going to be included, but B, wanted to make sure that we had some input from them. And obviously, utilizing the vast knowledge of Ed Martin and the ARCI, they've been regulating for years. So we wanted to make sure we did as much as we could, to follow essentially the same plan that the ARCI has been on, for a number of years, but just not been able to do it on a state by state basis being uniform.
Ed, ARCI had pushed for a compact a few years ago too.
Yeah. Yeah, 2018. Matter of fact, I actually asked Alex Waldrop and Ed to come speak to my executive committee. It was our conference in New Orleans, so it was March of 2018, because I felt the wave of HISA. I've been in Louisiana. I grew up there, know enough about hurricanes to know something's coming, and we don't know how it's going to shake out. And so I actually asked them to come down and talk about the compact and work to see if I could get my board at that point to get on board, but I couldn't do it.
Should I mean, based on what you said, it doesn't sound like this legislation is likely to move until the Supreme Court does. Is that
That's
accurate?
my gut feeling. Certainly my legislative affairs team may want to argue that point, but I haven't been doing this for for that long, but I see how it goes up there, and it's just one quagmire after the other. And obviously, horse racing is not important to anybody on the hill until it's important. And we saw that with Santa Anita and the tragedies there.
Yeah, no, you'd rather not. I used to lobby the hill a little bit, and on most issues, there's like 95% of members don't care at all, and a couple percent are for, and a couple percent are against, and then something happens to either break it through, or it gets dropped into something else. But
something else,
So then horse racing certainly falls in the
absolutely
nobody up there is going to care very much category.
Absolutely.
All right. So are you, certainly some people think HISA is going to get upheld when it finally does get to the Supreme Court. Are you optimistic that your arguments will prevail?
Yes, I'm very optimistic, to be quite honest. I feel as if the Fifth Circuit in particular mirrors the I don't want to say personalities, but certainly the maybe the beliefs of many of the Supreme Court justices that are sitting there now. So I do think that, and some of our legal team has worked with Judge Kavanaugh before he got appointed. So they're aware of, his understanding and belief. He actually is one of the ones that has called for a case to hear the non-delegation doctrine again. So that there is an appetite, I think, for some to really look at this. And I'm going to say it this way, and I don't want this to sound political, but the government overreach, I think, is very important to have reviewed, and make sure that the federal government is not encroaching on states' rights. And look, I'll go. I mean, one of the arguments I used, Frank, in the very early stages was PASPA, right? The Professional Amateur Sports Protection Act. PASPA was repealed for the very same reason that HISA exists. It's the federal government that put something into the states and said, you have to do this, or in PASPA's case, you can't do this. Sports betting. And it was repealed. The Supreme Court justices said they struck it down because, again, you're infringing on states' rights. It's government overreach. The states have to choose for themselves. And so in my eyes, it's a very similar case. And I would certainly feel as if when we get to argue the points, I think they're going to go our way.
So let me ask you this, and I'll have to let you go. But one of the things that to me is striking about the way HISA was created and the way it's organized is there's no structural accountability to the racing industry. That whatever accountability they feel is whatever accountability they feel. And I think by all accounts, Lisa Lazarus is trying to work with people and that they've been trying to be accountable, but they don't have to be, which I think is a very odd arrangement. It's one thing for the regulator, if you created a federal horse racing agency, they're accountable to Congress. They don't have to be accountable to the industry because they're the regulators. This is a different setup where it's, it always struck me as an odd arrangement. Do you feel like your RHSO would have any more accountability to the industries that it regulates?
I do, because again, when you look at every state racing commission, they're accountable to the governor. I look at HISA very much like you do, but not only who are they accountable to, I continue to ask who's really in charge. To me, I don't know who's the overseer of what they do. Who are they accountable to? But then I also go one step further and I don't really know who's in charge. And I believe under the RHSO, much like the ARCI, you're beholden to your stakeholders. Commissions are beholden to their state government, i.e. the governor. So again, there's accountability there. I mean, and look, there's plenty of people who are going to jump through the screen and say, racing commissions are just as bad and this, that, and the other. Of course they will. And it is what it is there, but at least it's accountable. At least it's an entity that is governmental. I mean, think about the fact that we cannot send a FOIA request to HISA to find out any information, that you can't FOIA them because they're a private entity. I mean, they get to make their own budget. And the only thing that the FTC, and this will probably draw some criticism for HISA supporters, but the only thing the FTC can do, and they've said it themselves, is make sure that the rules and regulations are consistent with the act. Consistency doesn't mean right or wrong, good or bad. It just means consistent. And I'm sorry, that's a pretty ambiguous statement as far as I'm concerned, for somebody that they think is in charge of this agency, this entity.
All right, interesting stuff. So HISA, however we want to say it, headed to the Supreme Court sooner or later, and you guys have a bill of your own waiting in the wings if the Supreme Court agrees with the case you've made. Eric Hamelback, thank you so much. I really appreciate your time.
Frank, it's always a pleasure, and thank you for allowing me to be on. I appreciate it.
Thanks to Eric Hamelback, CEO of the National HBPA. And of course, as always, thanks to you for watching, listening, and we hope liking and subscribing to Midlantic Racing Today. Midlantic Racing Today is powered by the Racing Biz, theracingbiz.com. We will be back later this week with 2 more episodes of Midlantic Racing Today, Delaware Park Today, and Charlestown Races Today. So check back often. Find the archives on theracingbiz.com. Have a great night. We'll see you next time.